Joining us this hour to discuss is National Trial Attorney Michael Jaafar. Michael, thank you for being on with both of us. Listen, at this point, we know that there are 4 gang members who were allegedly involved in this shooting, and we know this particular defendant, they are not saying was a gang member. She was with her boyfriend, but they are saying that she conspired, she assisted, she participated knowingly in this. Where do you stand on it at this point in time as we're hearing about all of the shooters, the many bullets that hit hotel rooms, that hit cars, and then the death of Julio Fulio, of course?
I think that this one is a very, very close one because of the fact that she was not covered like the other gang members. She was not part of the gang, and her involvement really is key. For me, what bothers me, Judge Ashley, is the fact that the charge she's crimed with have the same level of culpability as the people who actually fired the firearm. That's something I've always disagreed with in our jurisprudence system. I've always disagreed that a person who is culpable of helping or aiding I've never believed they should have the same level of charges or punishment as the people who actually did it. I've always felt that we're the only civilized country that I'm aware of that allows that. But for me right now, her case is a perfect example of what I'm talking about, which is she had some involvement. We have to find out what it is, and the purpose of this trial is to find that out.
Yeah, and I agree with you, Mike. This idea of charging her as a principal, I understand it because it's really applied and really came about because of things just like this, where you get this conspirators coming together, this type of just random, ugly violence. It's an ugly crime. But here's the thing, there is a little bit of a difference because she's not facing the death penalty, the others are. And that's the reason that she's being tried alone. Mike, I think that's a big win for her. If she's sitting next to 4 other defendants in this case, I think she's really doomed. Here, I think she's got a much, much better shot.
I like the way you broke it down. She does have a much better shot at success. But my definition of success in a case like this, I always imagine, if there's someone you love, and a young woman, and what if she was telling the truth? What if she really was going along for the ride? We know kids of this age are very impressionable. We have no idea it's a split decision to jump in a car and drive with somebody you may know, may not know what they're going to do. To have life in prison on the table for somebody which everybody agrees did not actually fire the firearm, to me, it's unconscionable.
And in this particular case, I think it carries weight that maybe it's true what the defense says, that she was with her boyfriend. Michael and I talked about this. She was with her boyfriend. She was simply going along with him because she was with her boyfriend. She says she didn't know the other men, the other guys, so she was there along for the ride. What is that line of when it becomes conspiracy? How much does she actually have to know for the jury to convict her of that, Michael?
What we learn in law school is when you find out about a conspiracy, the only way you can get out of it is you take affirmative acts to get out of it and stop the conspiracy. It's not enough to just leave the conspiracy. You're in it if you were in it from the beginning. If she found out on the way there that they plan on doing something, what if she found out that they plan on confronting him but not shoot him? Is that a conspiracy to commit murder? Some legal observers will tell you yes. Like I said, I think we've gone way too far, and I think we blur the lines and we conflate things that I don't think we should conflate. I think the answer is if she found out that they were going to kill him, by law, she's part of the conspiracy.
Okay.
All right, Mike, stand by. Let's step aside here for a break. All right, let's bring back in National Trial Attorney Michael Jaafar. And Michael, I want to get your assessment of the prosecution's case because we're towards the end of day 2. Haven't really even heard much about the defendant. And what the prosecution is hanging their hat on is a couple of things. One, she made a call to look into an Airbnb. She ultimately is not the one that books it. One of the other guys, one of the shooters, ends up booking it. She's in the car when the shooting takes place, and they claim that her mere presence was sort of a camouflage, right? To make them seem a little more legitimate and not suspicious. And she's relaying information. Now, not her, but her boyfriend's using her phone to relay information. So that's really the guts of their case as far as she's concerned. So talk to me about how strong that evidence is in your mind.
Zero strength to that evidence. This whole case is unconscionable. The way you've laid it out right now, for me, it's really upsetting. It's unconscionable that she's charged with this crime based on that evidence. I want anybody who's old enough to think about the JFK assassination and how long ago that was. That's how much time in prison she's facing if she's convicted of what the prosecution is charging her with. The distance between today and when John F. Kennedy was assassinated, that's the amount of time that this girl would serve in jail if she's convicted of what the prosecution is charging her for. To me, that is unconscionable, especially with the way you laid out the evidence just now.
All right, let me ask you about the actual investigation, because the scene is chaotic at best. You have multiple crime scenes. You've got shell casings, blood, lots and lots of shots, multiple victims. And here come, you just heard him say, all 6 of his officers, because it's a smaller community. And so how do you think law enforcement did with the investigation based on the testimony so far, where it seems like they really did follow their protocol, policies, et cetera, to investigate this crime?
I think they did a fantastic job. I mean, at the end of the day, these are human beings, right? And they didn't wake up in the morning and prepare for something like this that day. I'm sure they had. I've been in that community, by the way. It's a bedroom community. It's a very small, sleepy type community, and it's a stop for a lot of people on the way to Tampa. So at the end of the day, I think they did a great job. I would hate to be in that situation and to see that. I've never seen something like that live time. So I think they did a good job.
Mike, the defense is a bit hamstrung, right? One of the things they want to argue here is that she was kind of going along to get along, that her boyfriend, he was threatening, right, and he was controlling, and that's one of the reasons that she was there with him, even though she really didn't participate in it or even want him dead. She wasn't a part of the gang. She wasn't a part of that whole thing. That's what the defense is claiming. But they can't use duress. They said you cannot use it because this is a first-degree murder case, premeditated murder. You can't use duress. They said you can bring up some of the abuse that was in the relationship, domestic abuse, if she takes the stand. I think taking the stand is a tough choice for her. There's a lot of reasons why you wouldn't want her to do so, but I think that's a great reason for her to take the stand. What do you think?
I'm kind of a maverick in my profession because I put more than 50% of my defendants on the stand, and I had a very, very successful record. I think she has to take the stand. I think she has to walk the plank. I think the jury needs to see her speak, and this defense is perfect for it. And I did not agree with the judge's decision before the trial to not allow her to use duress. It has no bearing of any common sense that just because it's a premeditated murder, she couldn't use duress. I didn't understand that. To me, this is a kid. She was in the car with a bunch of gang members, allegedly. And so I think the whole thing is just completely unconscionable to me.
Yeah, fair enough. I agree with you for the judge's ruling, but it is settled Florida law that if you're charged with first-degree murder, duress is not a defense.
And that's what I was going to say, is it's not a defense. In the state of Florida, every state's a little different. Talk a little bit about the very thing that is a reason I think she might be sympathetic to the jury. Her look. Look at how she, I mean, I think they've done a beautiful job with her hair, with her makeup, with what she's wearing. And when I look at her, she's a beautiful girl anyway, but I look at her and I'm sympathetic to her plight as I sit there and see her physically, and the jury's going to take that into account.
Absolutely. If you get on the witness stand and you cry and you come off as sincere in a case like this, the jury is comprised of human beings who've all either been a girl her age or known a girl her age or loves a girl her age. There is no way that you can put her image next to the grizzled gang members in this type of a crime, and she's on the stand and she's sincere and contrite. It's absolutely going to move the needle.
Yeah, I agree.
There's no doubt. I spoke to a lot of friends. They all think her being a female is a real positive in this particular case.
Oh, that's an interesting point. With those 4 defendants that you see next to her in gangs, good look for her.
I agree. All right.
Thank you so much, Michael Jaafar, of course, for joining us tonight.